Welcome to this presentation on sexual harassment and discrimination under Titles 7 and 9. This webinar will satisfy New Mexico's annual training requirements for sexual harassment for primary and secondary education providers. Watching this presentation does not automatically provide the viewer with a certificate of completion. For purposes of properly documenting this training, it is recommended that school districts and charters have all employees who watch this webinar sign and date a standard form affirming that they have viewed the training for their employee file.
Hi, my name is Julie Garcia. I'm the Regional Director at Palms & Associates in New Mexico. Today we're going to talk about the discrimination and sexual harassment laws, both Title 7 and Title 9. The Civil Rights Act of 1964 is the landmark discrimination law. It's commonly referred to as Title 7 when we're talking about employer-employee relationships. It generally prohibits discrimination on the basis of race, color, sex, religion, national origin, age, adds citizenship status, and also added disability later. It covers all aspects of employment from recruitment to retirement, which would include any promotions or any other kinds of employment decisions. The law also prohibits retaliation for having filed a complaint, for participating in a complaint, or for opposition to an employment practice. It also covers former employees. It is not just restricted to current employees. So the Civil Rights Act of 1964, or Title 7, is administered by the Equal Employment Opportunity Commission. The education, or Title 9 piece, is covered by the Office for Civil Rights Department of Education. The way the two agencies operate is really quite different, so we'll go through that. So under Title 7, you have 300 days to file from the date of the last action. The last action, if you're complaining about a whole series of actions, the last action is the last time that something was said or done to you that you believe was discriminatory. If it only happened once, then that's the date of the last action. EEOC has the authority to issue a right to sue letter, and that is issued after an administrative investigation. In other words, EEOC has to conduct an investigation, make a decision, and then they issue a right to sue letter. There are cases where if the employee asks for a right to sue letter, EEOC may grant one without having completed the investigation. Sexual harassment was actually added to the Civil Rights Act as part of sex discrimination in 1980 as a result of a case called Meritor Savings versus Vincent. In that case, Roberta Vincent was an employee of Meritor Savings Bank, and she had had a long relationship with the branch manager, which she claimed was all against her will, and that when she said to the branch manager that she didn't want to have a relationship, then her promotional opportunities and her employment decisions were affected by her denial of the continuing relationship. And the Supreme Court agreed, and they added sexual harassment as a type of discrimination under gender discrimination. The definition from the EEOC is unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. When it's either made as submission to such conduct as either explicitly or implicitly a term or condition of an individual's employment. This is usually referred to as quid pro quo, or this for that. I offer you some kind of sexual conduct, you agree, then you go on with your employment. You disagree, you say you don't want to participate, and then I take action against you for your failing to agree. Submission to or rejection of such conduct by an individual is used as the basis for an employment decision affecting such individual. And the new one is such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. The hostile or offensive work environment is highlighted because this is the one that trips up most employers and employees. What constitutes a hostile environment? I'm going to use these two phrases. These are not legal phrases. The first one is it has to be sexually offensive. There are a lot of things in the workplace that are not sexually offensive, but are offensive. Bad breath is offensive, but it's not illegal under this statute. The other one is eye of the beholder. When EEOC comes in to look at a case, they're going to be taking first the individual who's making the claim. They're going to take that position and say that position created an offensive work environment. Then the employer has to prove that either that didn't happen or that it didn't rise to the severity in the definition. It happened only once, the person apologized, the apology was accepted. But the eye of the beholder standard is very important. If you think about people in the United States, we have a general personal space of about 3 feet, which is if you spread your arm out, it goes to the end of your finger. So anytime someone comes into your personal space, your fight or flight response is triggered. And that fight or flight response and how an employee reacts to the fight or flight response will set up that eye of the beholder and the standard from which EEOC will start. A good example is I had a young employee who got a job with the employer that I was working for, and she was going to be a library page. She showed up at HR on the 3rd floor of the library, and she said the HR director asked her if she understood the job, and of course she said that she didn't really. She'd read the job description, but really didn't know what it meant. She said, well, there's your supervisor. He's coming over right now. He'll explain what duties are of a library page. So he explained to her that in the morning she went down to the loading dock. She loaded up all the books. Then she had to take them up to cataloging on the 5th floor. Then cataloging would catalog all of them. Then in the afternoon, she would start in cataloging and she would deliver the books to the different levels of the library. He asked her if she understood. She said yes. They proceeded to get on the elevator to go down to the loading dock, and he had a dolly in his hand. The elevator doors closed. The employer or the supervisor, according to her, started rocking the dolly in a very sexual manner. As soon as the elevator hit the loading dock, she bolted out of the elevator and ran several blocks to EEOC and filed a complaint and said that he had rocked the dolly in a very sexual manner and that she feared for her life being locked in an elevator. Eye of the beholder, that's where they started. So the employer had to show that this gentleman had never done anything of that nature, et cetera, et cetera. But we also needed to know why she thought that he had done that. And it turned out that she had a very uncomfortable past. And as soon as the elevator doors closed, all of those past memories came out, and that affected her ability to see what was happening in a frame that was not sexual in nature, if that makes sense. So EEOC came up with this list, except for the last one, I'll explain that. Discussing sexual activities. I can't think of very many sexual activities that would be acceptable in the work environment. If you're a professor at a university and you're teaching an anatomy class, there may be some need to discuss sexual activities. And there's an exception for behavior and conversation that is customary to the job. So here's another example. I had a young woman who was a corrections officer, and she was assigned to the male corrections unit. She walked into the jail with all these men, and of course they had every different kind of name and activity to call her, all which were sexual in nature. She went back to HR and she said, I don't have to put up with this. And they were struggling with, well, you can't be a corrections officer and not put up with it. Another example is a nursing student who was in an anatomy class. She goes to the anatomy class. They're going to be working on a cadaver. And it turns out the cadaver is a male cadaver with all his genitals intact. And she says, oh no, I'm not going to be looking at these genitals. I'm not going to be working on this cadaver. And the argument was, well, she's going to be a nurse, so she has to be aware of the male anatomy. So those kinds of things are considered acceptable because of the job. But then there's another case involving an oil worker, a young man who went to work on an offshore oil rig. He gets on the offshore oil rig with all the other men, and he is repeatedly raped in the shower. He's repeatedly sexually harassed. After about a week, he gets on a helicopter and he leaves the oil rig and he goes to EEOC. The oil company's response was, well, that's how men acted on an oil rig. And the Supreme Court said, no, the behaviors were totally unacceptable and should not be part of being somebody who works on an oil rig. So there's a difference in those kinds of decisions. Unnecessary touching. In my opinion, anytime that you're going to touch somebody, you should ask if it's all right if you touch them, because for a lot of people, just invasion of that personal space and touching is unnecessary. If you're trying to teach a kid how to use a computer and you're leaning over the kid, that can be considered unnecessary and close contact, and it can be offensive to some kids. Again, I would ask the kid to either move away from the computer so that you can show them, or ask the computer, or tell the kid that you're going to be hovering over them to help them use the computer. Commenting on physical attributes. I have had participants in sessions say, never, never, never comment on how I look today. On the same hand, I've had other participants that spend hours upon hours getting ready to go to work, and a nice compliment is acceptable to them. The big thing with commenting on physical attributes is that you've got to know who you're talking to. In fact, that's probably true of all of this stuff. You may think that someone's your friend and that they're not going to mind, but the night before they had some issue with you, you did their performance evaluation, which wasn't positive. Suddenly their view of you is quite different. So be careful when you're commenting on someone's appearance. Crude and offensive language. Crude and offensive language is an eye of the beholder standard. There's a lot of crude and offensive language that happens in a high school that's acceptable to the students, may not be acceptable to you. As the adult in the environment, you have to let them know that's not acceptable. Letters, notes, emails, social media posts, and calls of a sexual nature. This was originally written when we used to get the obscene phone calls on our house phones. Well, now they don't, most of us don't have house phones, but calls of a sexual nature are showing up on cell phones. So again, the problem with a cell phone is usually you can see who it is that called you. The same thing with an email. Sexually offensive emails, you can usually see who the email came from. So if you're somebody who sends sexually driven jokes to coworkers, I would suggest that you stop, because everybody sees them and knows they came from you. And at any moment, any one of those can be sexually offensive and meet the hostile environment test. The last one, sexually suggestive graffiti, was a standard that was originally set by the Office of Civil Rights for Title IX, in which they said that all graffiti was going to be viewed as sexually suggestive graffiti. So here's an example. If you have Susie loves Johnny scribbled on a desk, how do you know that that's not sexually suggestive? It looks like maybe just two kids just writing notes to each other, but if one of the kids is offended by it, then it meets the sexually suggestive graffiti. This is a study that was done by the American Association of University Women, and there are 3 dates on here. The first one is this bar, the second one is the red bar, and the last one is this kind of teal bar right here. The questions that were asked is, has anyone made sexual comments, jokes, or gestures or looks towards you? So originally when the study was done, 82% of the male respondents said, oh yeah, and almost 92% of the female respondents said yes, that had happened. Well, as a result of this kind of survey, a lot of schools and a lot of educators started paying attention to what was going on. And you can see the numbers starting to drop pretty drastically. Showed you sexual pictures, photographs, messages. I just had a case where a student was walking around the hall showing pictures of one of his teachers who had bared her breasts on her cell phone and taken a picture of it. And the kid was walking around the hall showing other kids. That's got problems from the teacher shouldn't have done that to begin with, but it also caused some problems because a lot of the kids that the picture was shown to were really offended by it. Wrote sexual messages about you on the bathroom wall. Again, that can be as simple as Susie loves Johnny, although I've seen some bathroom walls where there's pretty explicit things written on them. Said you were gay or lesbian is number 5. Spied on you as you dressed or showered. They dropped that. Association of University Women dropped that in 2011. But we were aware of many cases where there were holes drilled into walls so that other people could peer in and observe kids showering and then make fun of them later. Number 7 is flashed or mooned you. Touched, grabbed, or pinched you in a sexual way. That was changed to touched you in an unwelcome way. Intentionally brushed against you in a sexual manner. That was changed to intentionally did something that was physically intimidating. Number 10 was pulled your clothing in a sexual way. That was also dropped in 2011. There used to be a thing called spiking, where you would run up behind a kid in gym class and you would pull down his gym shorts. That would have been an example of pulled at your clothing in a sexual way. Pulled your clothing off or down was also dropped, although we have lots of instances where we have bra straps popped. Can you imagine having a coworker walk up behind you and pop your bra strap? Common occurrence in schools. Blocked your way or cornered you in a sexual way. That was also dropped. Forced to kiss him or her in a sexual way is also dropped. And number 14 is actual rape. Forced you to do something sexual other than kissing, which is why I think they dropped 12 and 13. Now, if you look at the statistics would say that there's been some pretty significant decrease in these kinds of behaviors. And I think that's brought up by our awareness of what sexual harassment is and the effect of sexual harassment on continuing education. While I'm on this slide, let me tell you a story about, I was doing a training in an elementary school and way out in the rural part of New Mexico. And a second grade teacher started to tell me what she thought was a funny story about her son. Actually, she was probably a fourth grade teacher. Her son was in second grade. She wanted to tell me the story about her son. So her son, who's a second grader, got brand new pair of cowboy boots over the summer. Prior to that, he had always gotten hand-me-downs from his brother's cowboy boots. So having his own brand new cowboy boots was really a big deal. The first day of school, he puts them on. He goes running out the front door. His mom stops him and says, no, 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 no. These cowboy boots are for special occasions. He said, oh no, Mom, please, please. It's the first day of school. Let me wear them just this first day. So she says, okay. She's kind of a mother like me. She forgets about it. So first day turns into first week, turns into second week, turns into third week. After about the third week of school, he comes home, he takes off his cowboy boots, he throws them in his closet, and he covers them with his dirty clothes. Won't be caught dead in them. Finally, his mother realizes what's going on, and she sits him down. She says, what's the deal with your cowboy boots? Are they too tight? Do they rub on your feet wrong? What's going on? He proceeds to explain to her that there's a girl in his second grade class, and every time she sees him, she chases him. And when she catches him, she kisses him, and he doesn't like being kissed, and he can't run fast enough in his cowboy boots. Well, everybody in the training thought that was real funny, except his second grade teacher. And she got this awful look on her face. She pulls out this letter that she's about ready to hand to her colleague. And the letter basically says, I think we should get your son tested for attention deficit disorder because he's having a really hard time paying attention in class. She says, I now realize that he's having a hard time paying attention in class because this young girl has been passing notes to him all the way across the classroom. And my way to resolve it was to move both of them right up next to each other in the front of the classroom. And he's stressed all day long about where he's going to run when the bell goes off and it's lunchtime. And after lunch, where is he going to run? How's he going to get to the cafeteria first? At recess, he's stressed about where is he going to run on the playground to hide from this little girl. At the end of school, he's stressed about how's he going to get to the bus before this little girl catches him and kisses him. All of this had an impact on his educational benefit. And the second grade teacher says he's basically lost the first semester of school because he hasn't been paying attention, because he's been more focused on not being kissed. So this is an example of the kind of behaviors that we see that we may not think are serious, but when you look at what's the impact on the education, as in all these things in the AAUW study, there's additional information in the study about what percentage of kids as a result of this harassment said they didn't want to go to school, what percentage of kids as a result of this kind of harassment actually quit school. And we'll go into one of the cases that the Supreme Court talked about in a minute. So the education amendments in 1972 are Title IX. These recently just changed. There is a pending lawsuit which did not get a stay, so they went into effect on August 14th. The Title IX definition, or Title IX says, all 39 words of it, no person in the United States shall on the basis of sex be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So the key in the definition is federal financial assistance. Every public school in the United States receives federal financial assistance. You may get it filtered through your state Department of Ed, but you all get federal financial assistance. Even public charter schools get federal financial assistance. So federal financial assistance can mean special ed money, it can mean school lunch money, it can mean anything. So U.S. Department of Education changed the laws, changed the regulations. And they used these three cases. The first one is Franklin v. Gwinnett. The second one is Gebser v. Lago. Both of these established liability for sexual harassment activities. In 1999, there was a case called Davis versus Monroe County Board of Ed. Davis is LaShonda Davis is a fifth grader. She was subjected to all kinds of terrible behavior by this young man that she was afraid of. He would stalk her in the hallway, he would touch her, he would corner her, he would do all kinds of things. And she, on many occasions, went to the principal or the teacher and complained that this was going on and that she was uncomfortable. In one case, she went to the principal and said, "He's following me around in the hallway. He's stalking me." So the principal went and sat herself out in the hallway. And what happened when she was there? Absolutely nothing. He was a perfect angel. So she immediately started thinking LaShonda was maybe blowing things out of proportion. Then LaShonda went to her later and said, "He's touching me. He puts his hands inside my clothes. He backs me against the locker. He puts his hands down my pants." So they asked him again, "Did you do this?" And of course he denied it. And they assumed that LaShonda again was exaggerating. There was another instance where LaShonda was in a gym class and this young man was standing in the other side of the gym behind the teacher, making all kinds of offensive sexual motions. All of the girls saw it. All of the girls ran to the teacher. The teacher did nothing. She told them to sit down and pay attention and never reported the incident to the principal. So the Supreme Court, when they looked at the LaShonda Davis case, they asked, so what was LaShonda's ability to leave school and to go someplace where she wasn't being sexually harassed? Now, keep in mind, in 1999, there weren't a lot of charter schools, so there was not a lot of option. You either went to the public school or you did what the Supreme Court believed was your only other option, which was to drop out of school. They said that was not an option, that the educational institution or Monroe County Board of Ed should have acted appropriately when they had actual knowledge of what had happened. So they changed the definition to say school boards are liable when officials are indifferent to sexual harassment, which they believed is what happened with LaShonda because they never took appropriate action, of which they have actual knowledge. And the actual knowledge is that LaShonda told them that harassment is so severe, pervasive, and objectively offensive that it can be said to deprive the victims of access to the educational opportunities or benefits provided by the school. Clearly, when the Supreme Court said she only had two options, put up with the harassment or drop out of school, they did not believe that either one of those options were viable. So sexual harassment is administered by the Office of Civil Rights, Department of Education. The definition of sexual harassment as it exists today is an employee conditioning or provisioning the aid, benefits, or services of an individual's participation in unwelcome sexual conduct. Again, that's quid pro quo. That looks an awful lot like the very first definition under Title VII. Unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's educational programs or activities. Now, keep in mind, Title IX does not just cover students, it also covers employees, it also covers parents of students, it also covers vendors, it covers anyone who comes into contact with an educational institution that denies them equal access to the recipient's programs. The last part of the definition is sexual assault, dating violence, domestic violence, or stalking, which is covered under the Violence Against Women's Act. I haven't gone through those definitions, but it would be worth it to go through look at the Violence Against Women's Act and look at those definitions. This is all criminal conduct, by the way. So severe, pervasive, and objectively offensive is the conduct that effectively denies a person's equal access to the educational program or activity. Here's some considerations. The nature of the conduct. How often and over what period of time the conduct occurred. Obviously, if it's something that's ongoing, that's going to be more severe than something that just happened once. The circumstances under which the conduct occurred, whether the conduct was physically threatening or humiliating, and the extent to which the conduct unreasonably interfered with an employee's work performance or student's access to educational benefits. The work performance is the same thing as Title VII. I'm uncomfortable, I can't get my work done, and it's because of the sexual harassment that I'm subjected to at work from, believe it or not, another student or another employee. The student's access is usually, we're talking about sexual harassment at the hands of another student, although there is also sexual harassment at the hands of an adult. If it's at the hands of an adult, then you may be talking about criminal behavior. Violence Against Women's Act was initially signed in 1994. It's been reauthorized several times, most recently in 2013. It generally addresses domestic violence, sexual assault, dating violence, and stalking, crimes for which the risk of victimization is highest for women. So when the statute talks about the Clery Act, or VAWA, it also talks about the Clery Act. The Clery Act mostly applies to colleges and universities. It requires that they keep a log of the complaints and that they keep a log of all of the reaction to all of the complaints. If you're in a K-12 institution, I wouldn't necessarily disregard anything that's in the Clery Act, because there might be programs that are mentioned in the Clery Act that would be material to you in reducing claims. Student and employee rights, you must provide victims of the crimes with a written explanation of their rights. These rights include supportive measures, relocation, transportation, academic course assignment, counseling services, legal services, and law enforcement notification. All of these things are also supportive measures that have to be provided in a K-12 setting. So relocation may mean that you're moving a child from one classroom to another classroom. Transportation may mean that you're changing the bus route. Academic course assignment could be something that you're having to change for a senior in high school or a freshman in high school. Counseling services would be available for both parties. I'll just interrupt right now. Under Title IX, there are several things that really changed. One of them is the requirement for due process. Due process is written all through the regulations, and it says that you have to give everyone and all the parties an opportunity to hear what they're being accused of and to provide their side of the story. That's basically due process. And due process has to be made available to the respondent or the person who's accused of the sexual harassment. All disciplinary proceedings must be conducted by trained parties at the institution, either individuals or panels of trained parties. Title IX also talks about all kinds of different positions. You have to have a Title IX coordinator, you have to have a Title IX investigator, you have to have a Title IX hearing officer, and you have to have Title IX appeals people. These all need to be people who lack conflict of interest, which is the second big piece under Title IX. You cannot have individuals involved in this process who either have a conflict of interest or are perceived to have a conflict of interest. So actual knowledge means that the Title IX coordinator has received notice from anybody. It can be a teacher, it can be a coach, it can be a parent, it can be anybody. But the allegation of sexual harassment has to be provided to the Title IX coordinator. Now, there are different levels of allegations, and some students may decide they want to do an informal complaint. They don't want to go through all the hearings. That's totally fine, but it still has to be filed with the Title IX coordinator. Has to be sexual harassment in an educational program or activity against a person in the United States. So this is a point of contention when the rules were passed. If you have a program where you're sending students out of the country, or you're doing a field trip to Mexico, or you're doing a field trip to Canada, that's considered outside the United States. Therefore, if a sexual harassment incident happens while they're in Canada or while they're in Mexico, that is not covered as actual knowledge under the statute. However, you got to be aware of what the last bullet says, the downstream effects of harassment. So you may have a harassing incident that happened while you were on a trip in Canada, and 2 weeks later, all the kids at the school are talking about it. That's the downstream effects of sexual harassment. Will that have an effect on the educational benefit for a student? Absolutely. The next education program has to occur within the buildings owned or controlled by the district or by the school. A fraternity, the building may or may not be controlled by the school. The fraternity members' private homes are not controlled by the school and therefore not officially recognized by the district or the school as being a facility that belongs to you. So the two standards are, has to be in the United States, has to be in a program or facility that's controlled by the district or the school. Who does Title IX apply to? Everyone. Everyone who has contact with your school, whether it be a vendor, students, employees, parents, community members. That's why Title IX requires that you send out the definition of sexual harassment, the name, address, and phone number of the Title IX coordinator, and how someone goes about filing a complaint to all the people who have contact with your school. And that includes community members and or vendors. Unreasonable in light of the circumstances. Unreasonable in light of the circumstances goes to the definition of deliberately indifferent, which is the other thing along with equal access and equal rights and due process. The statute says that you cannot be deliberately indifferent. So deliberately indifferent means intentionally refusing to respond to the complaints. So in LaShonda Davis's case, she made several complaints that the school just never responded to. Intentionally delaying correction for a known injury. The worst extension of this is if the Title IX coordinator gets a complaint at the beginning of winter break. The Title IX coordinator cannot wait until January when winter break is over to start working on the corrective activities. They have to work on them immediately. Title IX also changed a bunch of definitions. We used to call a victim the person who was subjected to the sexual harassment. They are now the complainant. And the respondent is no longer the perpetrator. They are now the respondent to the complaint. This is all done so that it takes away any stigma and it works towards that equal access and due process. There's no definition or reference to consent. That does not mean that you can consent to sexual assault. When you have a definition of consent, then there has to be a corresponding definition of what is not consent. And that's just too much of a difficult burden to cross. How can you file a complaint? Anyone can file a complaint. It has to be filed with the Title IX coordinator, which is why you need to give the community and the parents and the students and all the teachers the information on who your Title IX coordinator is, what's their phone number, what's their physical address, what's their email address, what's the best way for people, anybody, to contact the Title IX coordinator and file a complaint. Anytime, day or night, weekends or holidays, you must post all that information about the Title IX coordinator. What's to be expected? Once the Title IX coordinator is involved, they're going to try to get the names of all of the parties. There are some exclusions for you may have a party that doesn't want to be recognized. They tell a teacher, this happened to me, but I don't want you to tell anybody. The teacher still got to let the Title IX coordinator know that this has happened, and the Title IX coordinator still has to do some level of investigation. The second thing is if a complainant or a person says they're being sexually harassed, the Title IX coordinator needs to offer supportive measures. Would you like counseling? Would you like to be moved? Do you need somebody to walk you to your car? All of those things are supportive measures that they give to the complainant. The supportive measures also need to be provided to the respondent as well. He or she may say, I don't want to be in the classroom with someone who's accusing me of such vile activity. So you have to be able to talk about moving them as well. They have to complete a complaint form. There is no such thing as a complaint without a completed complaint form, even a formal complaint. If the complaining party says, no, I don't want to file a complaint, it's still got to be filed in some manner. It can be filed by the Title IX coordinator on behalf of the complainant. A request for a formal complaint. The formal complaint initiates an investigation. At the end of the investigation, that initiates a hearing. At the end of the hearing, there is an appeals process. The appeals process is not going over the facts that were determined in the hearing. The appeals process is merely looking at whether or not everyone had equal access and whether or not everyone had due process. So due process in a hearing means that all the parties get to hear the testimony of the other parties. Now, in a university setting, Title IX says that has to be an eyeball-to-eyeball hearing. I need to be able to look my accuser in the eye. In a K-12 setting, it's not so true because they understand the dynamics of having a young child having to complain about something in front of the respondent. So they've allowed for interaction via advisor or via the hearing officer. But at any rate, that all of the interaction, whether it's in person or it's videotaped and provided, has to be provided and given both parties an opportunity to respond, including to all the witnesses. There are retaliation prohibitions. You cannot be retaliated for participating in a complaint. You can't be retaliated for having filed a complaint. And again, you can't be retaliated against for opposing what's considered to be illegal activity. This is my contact information. Please feel free to call me if you have any questions. The 797 number is our office number, which is closed right now, but if you call that number, they will route you to me. Or you can just call me directly on my mobile phone, or you can send me an email at jgarcia@palmsassociates.com. We have done a series of webinars. This is only the one that talks about the definition of sexual harassment and the one that needs to be provided for employees and the community and students. We can modify this if you'd like to have it modified to be shorter or longer. We can also do the presentation in a Zoom meeting or face-to-face, however you choose to do it. But this is the one that meets that first test. The second one is what's your obligation as a Title IX coordinator? That is also available on the website. The third one is how do you conduct an investigation and what are the requirements of the investigator? And the fourth one, which we'll be recording probably in a couple weeks, is the obligations and the duties of the hearing officer. Now, the hearing officer is probably the most complex because the hearing officer really becomes the judge. They're the ones that are going to be determining the correctness of the facts, the preponderance of evidence, or the clear and convincing evidence, whichever standard you choose. And the subsequent webinars will go through those standards for you. So that's the end. If you have any questions, please feel free to call me. Thank you.